answer, I don't think you hear me. I don't even answer Rhonda when she sends stuff out anymore, where everybody else will reply, yes, I got it, okay, thanks, and stuff, which I used to do. I'm just not even doing any of that, so.
Yeah, and let me make some distinctions, because I give more than a few speeches on this topic on digital communication, home info in the world of digital communication. It's generally acceptable for somebody who runs or organizes a meeting to send out a one-way missive to all the members to say, here's the agenda and here's what we're going to be talking about. It's okay to inform people. That's not a form of deliberation. To give you the information for the meeting. But what I always tell them is the reply all function is the devil's friend. Never use reply all when you respond to one of those messages, because then it's going to everybody. And if you're commenting on a matter of public policy, all of a sudden you've got a quorum that's engaging perhaps in a discussion, and therefore it's a private meeting in violation of law. So it's okay for Rhonda to send out those one-way communications to a group. It's okay for Jack to do that as the chair. It's just you don't want to get into the reply all function or start engaging in some sort of round robin discussion between all of you.
Chairman, point of order. Would you please check your bylaws just to read what it says about reclusing and contacts for conflict of interest? Would you also go back in your minutes where we had this discussion as a PC and came to the agreement that the only thing that would be texted would be the words, check your email, please. And that was an agreement the PC board made for communication for texting.
We will check those after this meeting going forward. Okay, Mr. Olson, will you step out for the duration of this meeting then? In the audience, please. No. Just in the audience is fine. Okay, let's move on to the ordinance now. I think I'll have Ron and Paul go ahead and go through this draft that we have in front of us and explain what has happened with it.
All right, before getting into some of the minutia of the provisions, some of the big items that happened at the last meeting, if you will, was a request to refer the sound testing methodology to Spicer, the Spicer Group, for a explanation of where those standards came from and whether they are in fact achievable. And second, to have them comment on the use of the LMAX standard versus LEQ standard. They have provided a response to that in a May 5 letter. The short of it is that the sound testing methods and procedures were in fact used in Huron County and prepared by a professional acoustics company, Acoustics by Design, and they have been successfully implemented within the Huron County projects. So it'd be incorrect to say that those procedures are somehow infeasible or not obtainable. They have been done. On the question of LMAX and LEQ, there's not necessarily a right answer about that, except that LEQ is a more or less stringent standard than LMAX, and that LMAX requires that the sound level never be exceeded at the property line, whereas LEQ, as has been discussed, is an averaging function. And so it is somewhat less strict because there can be momentary exceedances of whatever your level is. I point out it's somewhat misleading though to refer to it as an averaging because averaging would suggest that you're looking at a 24-hour cycle, and so you're averaging, maybe the turbine makes a noise of 70 dB at one time and 0 at another, so the average is 35. That is not at all close to what LEQ means. LEQ is always defined on a time interval. Very often it's 10-second averaging. And so you're averaging the sound over a 10-second period. And when ordinances are written to use LEQ, they are written in a way where the loudest time period is used for the averaging. LEQ is a standard used in Mason County for the Consumers Energy Lakes Wind project there. And the way LEQ was applied and could be written in the ordinance as it was there is that the testing would be done at the loudest time the turbines are operating. So So not only was it not just a 24-hour period, they went out and purposely tested when the conditions were such that the turbines would be operating at their loudest, and then picked the loudest 10-second segment and took 10 1-second readings and averaged those 10 loudest readings. Okay, so it's not, as it has been portrayed, as this wildly inaccurate figure, because it is not even close to your general concept of averaging everything over time. Now, that said, either one is appropriate and can be used. There is a case from, I believe it's Isabella County, where the court generally upheld the use of an LMAX standard in that ordinance and rejected a claim that it was exclusionary on its face. The ultimate issue here is a policy decision. LMAX is an enforceable legal standard that you can use. It's a policy determination, or if you want to use that stricter standard of LMAX versus LEQ. Okay, so those are the Spicer issues. For the Planning Commission, any questions on that before I go on to some of the other major topics? Okay. One of the other big items was the effect of the seaplane base on Clifford Lake. We retained the services of an expert in aviation law on this, who's presented a memo to you, which has been provided. The short of that is there will be some impacts as a result of that, provided that airport is licensed by the Michigan Aeronautics Commission, which, based on my discussions with the seaplane base owner, is likely to occur. The general effect is that structures higher or taller than 200 feet would be prohibited within about a 1.89 mile radius of the runway. It's I forget the exact dimensions, but it's 2,000 feet by, I think, 200. The 200 figure might be off, but it's 2,000 feet long. So in effect, what you have is a racetrack shape around that takeoff and landing strip, where generally anything over 200 feet would be prohibited. Now, it's actually shorter than that as you get closer, because the way the regulations work under Michigan's Tall Structures Act is that there's a slope of a 50 on 1 going out, where you get to be 1 foot taller for every 50 feet you go out. So it's 10,000 feet out where the rule applies. 50 into 10,000 is 200 feet. So at the very edge where the restriction ends, 200 feet is the cutoff there. You couldn't go higher than 200 feet within that 1.89 mile radius. Paul has put together for you a map that illustrates the effect of that. It's really not that great. There's some of the smaller areas in the southwest portion of the township that are cut off a little bit. But for the most part, most of the areas that were otherwise available under the existing standards are still available. And just one caveat to that, I point out that 200 feet within the 1.89 mile radius is the default. It is possible for somebody like Apex or anybody else who wants to construct a tall structure, for that matter, whatever it may be, to seek a waiver, if you will, from the Michigan Aeronautics Commission by doing an airspace study where they can show that a taller structure would not necessarily present an obstacle or impediment to aviation. Whether anybody could do that in a particular circumstance is impossible to tell, because that's a very detailed analysis. So the end result, though, is that this has very little impact on the ordinance as you've drafted it. So the presence of that base is certainly not a reason to discontinue working on the ordinance as it's been prepared.
You said 200 feet, and there's 600-foot windmills. That's three times what you said. I mean, come on.
But to address the question, if I haven't been clear, within 1.89 mile radius of the takeoff and landing runway, you cannot go over 200 feet. Outside the 1.89 mile radius, there is no restriction whatsoever on the height. So you could put the 500-foot turbine 1.9 miles outside that radius, okay? And that's not a township decision, that is the regulations under the Michigan Tall Structures Act, okay? The final issue that I've given you some communication on, dealt with, and it's been brought up tonight the 2017 ordinance. And I felt after the fact, I did not do a very good job explaining in the context of a very contentious, angry public meeting, why I think it is fair and a good thing that you include that 2017 ordinance as part of the saving clause I described. And I know there's a lot of mistrust, but I want you to think closely about this in this context. The 2017 ordinance is on the books, okay? It is there now. So if there's a referendum on the new ordinance, the default is the 2017 ordinance. No questions have been raised about whether it's valid in view of the irregularities in the adoption process. It is not anywhere near certain that such a legal challenge to that would survive. It has been over 4.5 years since that ordinance was adopted. There's case law that have refused to invalidate ordinances based on how long they've been on the books for 4 years. So we've already exceeded one of the cases which refused to invalidate an ordinance that's been on the books so long, despite procedural irregularities. Now, the irregularities aren't the same. In this case, there's a failure to publish a notice of adoption, which is arguably a more serious deficiency than was reflected in some of the other cases, where it was failure to give proper public notice of the hearings and so forth. So that is a difference. But it's been suggested that somehow there wasn't the same type of public reliance on the ordinance here like there was in the other cases. I would suggest that that's a rather myopic view coming from one position. There has been, from what I've seen, quite a bit of public reliance on the 2017 ordinance by virtue of those who have deemed that wind energy projects are a viable thing in Douglas Township based on the 2017 ordinance. A lot of people have executed leases because of that. There's been a company that's expended a lot of resources in starting to develop an ordinance. So I know there's a lot of people who don't want this type of project in the township, but the idea that theirs is the only segment of the public that hasn't relied on this ordinance is just not correct. There's been a great deal of reliance by others. So the end game is there's a significant chance that if there is a referendum on the new ordinance at all, the 2017 ordinance would be on the books and Apex or any other company could take advantage of it. So getting to the point of fairness I've been trying to communicate to the public is I think the fairest way to deal with this issue, because you were effectively deprived of the opportunity to seek a referendum on the 2017 ordinance because the notice of adoption was not properly published. If it is readopted as part of the saving clause, meaning that it would only go into effect if there was a referendum on the new ordinance, okay, it would renew your ability to seek a referendum on it, okay? So you would have that right again that you were deprived of before. I feel that is a much more valuable right to the public than the risk of the 2017 ordinance staying on the books. And on top of that, you would have to mount a very expensive lawsuit to try to invalidate it. It just doesn't automatically become invalid, as has been suggested, just because somebody's pointed out some deficiencies in the adoption procedures. It is presumed valid unless and until somebody goes into court, files a lawsuit, and has it invalidated. That's an expensive and time-consuming undertaking, much more so than it would be for you to potentially exercise your referendum rights on it. So when I tried to explain that I think this is the fairer option to leave it in the ordinance, that is why. And it's why I still recommend that you do that. Now, ultimately, it's your policy decision, but I wanted to give you a clearer understanding of why I'm recommending that remain in the ordinance. So I suggest you reconsider that again tonight. Okay.
May I ask a follow-up question regarding the airport? Looking at our zoning ordinance, we're very specific in our lake residential districts. There is a flavor and a quality of life that we expect to be in those, right down to the fact that your people who live there are not even to give non-family members access to the lake off their property. They're to use the public access. There's prohibit with new businesses and things that were grandfathered in at the date of that ordinance. Our ordinance does not contemplate an airport, especially for commercial. And after 3 years of life safety noise, and all the other concerns that have come up, is the airport viable or in compliance with our zoning district as our zoning law right now as on the books? Or have they entered into a business that is not a non-conforming use?
Well, that's a tricky question. As a general principle, FAA regulations do not preempt local zoning regulations. So the mere fact that the seaplane base has been registered with the FAA does not preempt anything in township zoning. And it's only if they get it approved by the Michigan Aeronautics Commission that this 1.89 mile radius goes into effect. Now the tricky issue of this is landing a seaplane an activity or a land use? Because zoning doesn't regulate activities, it regulates land uses. And arguably, much like you transport yourself around in a car is not a land use, so too is flying and landing a plane not a land use, it's an activity. So I think there's a fair argument that by using the lake as an seaplane base, that does not in any way violate the zoning ordinance. That's not to say, however, that the township could not adopt a regulatory ordinance that prohibited seaplane landing on a particular lake, because in fact there was a case on that particular subject where it was held there that FAA regulations didn't preempt local ordinances because a particular township did adopt a regulatory ordinance that prohibited seaplanes on a particular lake. It was challenged as being preempted, and the court held no, FAA regulations do not preempt local regulations on that subject. So my answer to you is twofold. Is one, I think it's unlikely that its presence violates the zoning ordinance, but if the township wanted to prohibit this type of activity on the lake, it probably could.
So if there is a business that is a non-conforming business use at the lake, then it would be in violation. If it's just a matter of planes coming in and out and landing there, then it is not. Is that how I'm understanding that?
That's a fair demarcation, because if you're actually running a business where you're charging people I'm not sure what you would charge for in connection with, a water landing strip, but maybe
Storage, landing.
So if there's that type of commercial activity going on, then that could probably be enjoined under the zoning ordinance. But the mere fact of the lake being available for a registered FAA seaplane land use strip would not violate the ordinance. It's only the commercial activity that might go on with it that would violate the district regulations.
Any other comments, Ron? Or do you want to get right into it?
Those were the big things. I think everything else is more in the planning discussion realm that Paul can assist on if you have questions.
Any other questions for anyone? Okay, Ron, go ahead and dig into it.
All right, the changes we've made to the public hearing draft since the last meeting are just two. Page 4, someone noted last time that Lake Christina and Lake Hemingway are also located in the township. So we've added that to paragraph 2C on page 4 to include it with the other lakes. So like those other lakes, there would be a 1 mile separation distance or setback from the lake boundary for any future wind turbine. And the map that I provided you illustrates that. And then the other change is on page 36, and that's a new paragraph P as in Paul. That was actually recommended by Ron regarding ground leases for WEX sites. And maybe you could explain the rationale behind that.
Yeah, I'm sorry, this is probably one I should have touched on as well, but this is something that has come to my attention in the context of dealing with other tall structures, in particular wireless communication towers. that the position has sometimes been taken that the lease of the ground site for those structures is a land division under the Michigan Land Division Act. Because the Land Division Act does define a division as a lease of real property for a duration of more than 1 year as a division. Well, that being the case, if that rule applies to the lease sites for a wind turbine, then the lease site creates a parcel in and of itself that in all likelihood would not comply with the dimensional requirements of the zoning ordinance. So the reason this provision has been added to make clear that that type of parcel that's created for that unique purpose does not have to meet the minimum dimensional requirements of the district it's in pertaining to lot size, lot width, and things like that. Because I don't think that was the intention in the drafting, that every single wind turbine would have to be on a lease site that complies with the minimum parcel requirements. It, of course, has to be on a larger parcel that complies with those requirements, because otherwise the parcel wouldn't lawfully exist. Now, this is an unsettled issue, and there hasn't been a court that's opined on this yet, but I think it's important to have it in there so that it's clear that if there's a challenge on that basis of one of these lease sites, that you've got language that says it doesn't have, the lease site doesn't have to comply with those dimensional requirements.
Is that gonna impact we're not creating a parcel though within the parcel, it's only within the lease? You know, we just have you only can divide so many times before it, you know, I'm trying to make sure it doesn't count against subdivision, giving land to children, whatever it happens to be, that isn't gonna count as one of those times.
Well, that's the unsettled question. It's a very good question you asked, and Paul had brought that up too. Ultimately, though, that's not the township's question to answer, because this opinion is based on the language of the State Land Division Act, which the township wouldn't have the option of saying, no, that lease isn't a division. If it's a division under state law, it's a division anyway. So if a court ultimately accepts that interpretation that these lease sites are divisions, it will count against the number of divisions that can be taken. I'm not going to express a final opinion on that, except to say that it's a possibility, and so that we need to address it some way. If individual landowners are impacted by that because it essentially consumes one of their divisions, that is what it is under state law.
Okay, but that's a state level, not
Yes.
township, thank you. Can I ask a question for one? So Paul and Ron, I have a question as we're looking through here. We have the word waive or waiver in a couple of locations. And I think the intent of those paragraphs was that, to me, the waive by definition should only be extended if the authority having jurisdiction waives it and not a discretionary of the planning commission. So if the items we have in our checklist are required under this ordinance, I don't think we should have, you know, for future generations to waive those restrictions discretionary. So do we need to really look at adding a waiver definition and what that means?
Can you point out where that's found?
Yeah. It's in a couple of locations. It's on page 11, item number 2, where it says the planning commission may in its sole discretion waive or defer. And I don't think that waiver should be discretionary. If it's waived by an authority having jurisdiction, that's one thing that's not applicable, but I don't think we should allow that to be discretionary.
Do you want to address that again?
Well, yeah, I understand your concern. I don't think we necessarily need a definition for that. The concept of waiver is something that you'll pretty commonly see in zoning ordinances, and I don't think there's a whole lot of uncertainty about what it means. And the context in which it's used in the ordinance is not the idea that we could waive the requirements of the FAA or waive the requirements of Eagle or anybody else who has jurisdiction. This has to be read in the context of understanding that the planning commission can only waive what we have jurisdiction to either require to be submitted or require to be performed. And it's limited by the language that the planning commission has to determine for some reason that the item is not relevant to the request, or it's not relevant at that time, so it can be deferred to a later date. So I don't have a legal concern with that language, given that that's the context in which it must be read and interpreted.
Also under the definitions where we have the participating landowner and it refers to the owner of a participating parcel. Several of us have multiple parcels. So is that really from the outer bounds of a contiguous parcels? How is that defined there? You know, you could have 100 acres, but there's really 5 20-acre parcels. I'm just trying to understand how that's gonna be applied when you look at this from a complaint. You know, Ron brought up the concern about, you know, we're gonna have to be able to manage complaints and other things that happen. And I'm trying to understand how the participating parcel is impacted when there's contiguous parcels with a single owner.
Well, if you read the definition of participating parcel, it says any parcel of land that participates by ownership, lease, or easement agreement or other contractual arrangement with a person essentially applying for a special use permit. So if you have multiple parcels, it wouldn't include all of your parcels. It only includes that described parcel on which the lease agreement is placed.
But if they have multiple parcels and we have a setback from a parcel line, depending on how those parcels are defined, even if they're participating, they're still gonna have a setback from a parcel line, as I understand this, unless it's contiguous. And you can look at contiguous parcels on a whole. So if you can imagine 20-acre parcels and you go 15 feet, whatever our setback is, and you go 15 feet from the other way, you could in fact take someone who has 100 acres, but 5 20-acre parcels and exclude them with the setback. Just trying to understand what happens when they have contiguous parcels, depending on the dimensions.
Well, the setbacks would be measured from the location of the tower to whatever, whether it's a wetland or a lake or any of the other things we've listed under the applicability section. Whether or not you have contiguous parcels under the same ownership really isn't relevant, because you're dealing with the property boundary of the parcel on which the lease agreement is held.
There's a legal distinction, Tammy, between parcel and what you're talking about is a tract. You got several parcels that are in common ownership and contiguous to each other, it's a tract. And we're purposely using the parcel term here. So it will be, those setbacks are all determined from that discrete parcel, not from the boundaries of the larger tract.
I have 3 individual parcels that make up my 60. They're not tracts.
No, I mean, they are tracts. That by definition, when you've got contiguous parcels under common ownership, collectively they are a tract. And we're not using that phrase in the ordinance, so the setbacks won't be determined from, let's say you had 3 20s and your wind tower lease was only on one of them. Any setbacks that were measured from the boundary line of that particular parcel would be that parcel alone, not the other parcels in your, that are within that same tract.
on the item that was inserted, I've not been able to bring up before. This is, G, procedure number 1, paragraph 2, the pre-application conference. It says the pre-application conference with the public at a location within the township. I would like to add, or the location within the county in close proximity to the township residents to accommodate a large audience. On 9, bottom of 9. I believe that should ever a pre-application conference occur, that there will be a large audience in attending for various reasons.
So you wanna both indicate that it can be within the county and that it has to be in a public space big enough to accommodate
Correct.
something easy enough to do.
I mean, whether they have to, rent one of the local school gyms or whatever it is to accommodate, but I think it's unfair to those that wanna publicly attend this pre-conference to be in a small spot which they cannot attend and be at comfort and ease doing it.
Can that just be inserted, Ron?
Yeah, that's,
It's,
yeah, it'll fall on, I can pretty easily make that change.
can I keep going, folks? On page 15, under insurance, this is the, not per tower, this is the regular general liability. I would like that to be 5. And like the employer's, liability insurance, automobile and other items to be 2 million instead of the 3 million and 1.
You go through this again, I heard you wanted 5 million in the first main paragraph, CPL, but
Yeah, and then 2 per accident. I think that's in item number 3. And number 4 also only references 1 instead of 2.
that's an easy enough change to make. Any discussion on the planning commission?